And the real action is too often offstage in an archipelago of right-wing dark money front groups out to capture the court. That is where the real story lies. When Republicans appoint to the Supreme Court, the selections come out of that archipelago of front groups, paid for by big anonymous donors, what we call dark money. When Democrats appoint to the Supreme Court, their objections come out of that same archipelago of front groups paid for by big anonymous donors, the dark money groups. We have heard a lot about judicial philosophy during the course of this. Well, if you bring a judicial philosophy to these proceedings, I think we do need to examine it, because the judicial philosophy is so often a mask for predispositions. Originalism works very nicely for you if you'd like to look back before the civil rights movement in making decisions about civil rights. Originalism works very well for you if you'd like to look back before industry regulation at a time when there was no industry big enough to regulate and serve the interests of corporate deregulation. And originalism works very well for you if you want to return to old social norms that society has moved beyond. So let's not pretend that a judicial philosophy is a neutral thing. It is a tool, and when a judge says he or she has one, it's worth looking into. But that doesn't mean you have to have one. There's a group called the Independent Women's Law Center, which, like many of these right-wing front groups, is twinned with another group, which is called Independent Women's Voice. One is the 501c3, one is the 501c4. Their funders are Leonard Leo's 85 Fund and Concord Fund, another pair of 501c3, 501c4 twins at the heart of the court capture scheme. They're also funded by the Koch and Bradley Foundations, who I've talked about before in these proceedings. Indeed, for years, the president of one of these groups was actually a Koch Industries lobbyist and overlapped for a while with Americans for Prosperity, the Koch brothers' huge dark money political operation. And they, on February 24th, before they even knew who the nominee was going to be, sent a memo to GOP Senate members. Ray suggested SCOTUS talking points. Date February 24th, 2022. Here's the punchline. It is therefore important that you focus not on the selection process or on the nominee's paper qualifications, but rather on the need to learn more about the nominee's judicial philosophy. Ask unanimous consent that the memo from those two front groups be put into the record.
Without objection.
The other theme we hear a lot about is how this judge was going to be dangerous for children. And once again, we turn to a right-wing dark money front group as the source for that concern. On the day of her announcement, February 25th, a group called the American Accountability Foundation came out with an investigative report. Now, let's look at the American Accountability Foundation. It shares an address and senior staff with a group called the Conservative Partnership Institute, which employs, among other people, that wonderful Cleta Mitchell as a senior legal fellow. Indeed, the Conservative Partnership Institute is the so-called care of name in the filings of the American Accountability Foundation, and it also shares an address with something called America First Legal. American Accountability Foundation is funded by Donors Trust, which is described as the Koch brothers' right-wing ATM, and the Bradley Foundation, which I've, again, spoken about before in this hearing in this context. And it was founded by the opposition research director of none other than Cruz for President. So they got right to work the day she was announced. And AAF founder Tom Jones said, after calling her a radical leftist, which I guess they figured out that very first day she was announced, Americans want our judicial system to protect children and citizens from sexual predators. I'm going to ask unanimous consent that that dark money release be put into the record.
Without objection.
So the continuing problem of these outside groups that are funded by huge interests that hide who's behind them and that exert control when Republicans are in charge in the selection of the nominees and when Democrats are in charge in the objections to the nominees is something that I think needs to be brought to the surface. So I wanted to make that point with those two arguments. I'd also like to point out, just because I've been a prosecutor and seen some of this stuff, and spoken to Rhode Island judges, federal judges about this, I'm told that the two most disfavored guidelines in the entire sentencing scheme are the crack powder cocaine disparity and the pornography possession guidelines. And that's widely accepted throughout the judiciary, which we've heard from many other members of the judiciary. And that would help explain why, in so many of these cases, the government actually recommends below the sentencing guidelines. The government, which usually is making the harshest sentencing recommendation, is actually recommending below the sentencing guidelines. It's hard to fault a judge for a sentence below the sentencing guidelines when the harshest participant in the courtroom, the government, is recommending below the sentencing guidelines. And as those of us who've been there know, every judge faces three data points in a sentencing hearing. One is the position of the government. The second is the position of the defense. And by the way, in our system of justice, a judge is pretty much honor-bound to give fair consideration to the recommendation of the defense. You can't rule out the defense's recommendation just because they're representing the defendant. They're entitled to an honest consideration of their views. And then there's the probation office, which serves the court and makes its own recommendation based on an exhaustive personal review of the defendant, of the family, of the victims, of the circumstances, and comes up with a sentencing recommendation. And when you look at all three of those data points that a judge has to face, and when you look at the widespread acceptance of the fact that this particular sentencing guideline is widely thought across the judiciary to have a serious problem with it, and you actually look at where these sentences fall in that actual matrix, there is nothing to see here. This is all part of what was cooked up by the former opposition research director for one of our colleagues, this dark money funded American Accountability Foundation. With that, I think it's unfortunate what she had to go through. I think what's really unfortunate is whoever's behind all this nonsense doesn't just stand up and show who they are. Admit it. Show who wrote the check to the Judicial Crisis Network for $15 million or $17 million. It's a pretty big check to write. Who wrote that check to get the ads up on the air for Kavanaugh? Who wrote that check to get the ads up on the air for Gorsuch? Who wrote that check to get the ads up on the air for Barrett? And what business did they have before the court that caused them to write checks that big? That is a mystery that we need to solve. There's been a lot of criticism of dark money on all sides of the panel here during the course of this discussion. Well, everybody's going to have a nice chance to prove it in the months ahead when we bring up the Disclose Act for a vote, and we're given the opportunity to get rid of this poisonous stuff for once and for all. Thank you, Chairman.
Thank you, Senator Whitehouse. Senator Lee.